Good evening. I am Mayor Donald T. Lopez, Village of Los Ranchos de Albuquerque. I want to welcome everybody to our Board of Trustees special public hearing. I'm calling the meeting to order at 5 p.m. The Village of Los Ranchos is providing streaming service of this meeting. As with any application, digital service, or software, the opportunity for failure can occur. Therefore, the village is not responsible for the inability to view via live stream. The meeting video and audio is recorded and will be available online after the meeting on the village website. At this time, I'm going to call the roll. Mayor Pro Tem, Trustee Pacheco.
Present.
Trustee Benavides. Present. Trustee Lewis.
Present.
Trustee George Radnovich will not be able to attend the meeting tonight because he feels he needs to recuse himself due to his past work on the project. At this time, I'd like for everybody to stand and follow me as I lead in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. I'm moving to item 4, approval of the agenda. I need a motion to approve or amend the agenda.
I'll make a motion to approve the agenda.
I need a second.
I will second that.
I'm going to call for the question, call for the roll call vote. Trustee Pacheco.
Yes.
Trustee Lewis.
Yes.
Trustee Benavides.
Yes.
Motion carries unanimously. Item 10 is public hearings. The following will apply to items of business A, B, and C. First and foremost, please be polite and respectful to everyone who comments tonight. Thank you. I want to take this opportunity to address the process, what constitutes the record, disclosure of any ex parte communications, and conflicts of interest. I will address conflicts of interest first. Various matters presented to the governing body for decision may present the potential for conflicts of interest for individual officials. It is the obligation of each official to declare for the record any instance where a conflict of interest or the appearance of a conflict of interest might exist. Such official must then withdraw from further deliberations, including participation in discussion and decision-making. Trustee Radnovich has recused himself. I would like to ask each member for full disclosure of real or potential conflicts of interest with this item of business. I'm going to start with myself. I have no conflict of interest of any kind. Trustee Pacheco.
I have no conflict.
Trustee Lewis.
I have no conflict.
Trustee Benavides.
I will not be recusing myself, but I should disclose an incident that happened in regards to an email that went out to the trustees that was followed up with an email by our legal counsel suggesting that it was ex parte. So the issue for me is it went to a personal email called Gil for Los Ranchos, and if it gives the appearance that I've been communicating on a personal email with an individual, and I want to assure you, my fellow trustees, that I have not been doing that. And if it's, I would be willing to allow you guys to look at my email or any of the council to look at my email that go for Los Ranchos. I will not recuse myself.
Thank you, Trustee Benavides. Now I'm going to talk about the process. I will now address the process. Both village ordinance and village resolution apply here. Section 9.2.25 parentheses H of the ordinances guides the process. That ordinance refers to the resolution titled Rules for Appeals. Pursuant to the Rules for Appeal, I may limit oral presentations by applicants, proponents, opponents, and other testimony in the interest of time and orderly proceeding. Based on this guidance, we will be adhering to the following time limits, which will apply to the interested parties as follows. Appellant / applicant case presentation, 45 minutes. This is total time for the opening and presentation of witnesses. Then appellees' questions, 15 minutes. Total for cross-examination of any and all palindrome witnesses. B, followed by trustee questions. There is no time limit. Next, Appellee case presentation, 45 minutes. This is total time for opening and presentation of witnesses. C, followed by applicant questions, 15 minutes total for cross-examination of any and all Friends of Los Ranchos witnesses. D, followed by trustee questions. There is no time limit. E, public comment in favor/opposition, 2 minutes per person, but only commentators who spoke at the planning and zoning meeting. These commentators should not include any person who is identified as an applicant in this case. I understand that all interested parties were informed of these time limits. In accordance with the rules of appeals, all appeals to the Board of Trustees shall be deemed quasi-judicial proceedings, which means certain judicial processes and protections are required. All testimony must be given under oath and shall be limited to matters relevant to the appeal. All testimony and questions shall be asked through the chair. The chair will acknowledge those who want to give testimony or ask questions, as well as enter into the record communications received from the public concerning the pending application. All persons participating in meetings of the Board of Trustees are expected to conduct themselves in a courteous manner. The Board of Trustees shall render its written decision within 15 days of the hearing. The written decision shall include an order and the factual and legal basis for that order. Now let's move into what constitutes the record. I will now address the record of this appeal. Section 9.2.25, parentheses H, parentheses 3, parentheses C of the village ordinances provides a notice of appeal from a decision of the Planning and Zoning Commission must be specifically state the basis of the appeal, including citation to any law, village master plan, applicable sections of ordinances, and specific references to evidence or documents which were considered by the Planning and Zoning Commission. Without a specific authorization by the Board of Trustees, no factual information not available for consideration by the Planning and Zoning Commission will be considered by the Board of Trustees, nor will any person or entity not participating in the hearing before the Planning and Zoning Commission be permitted to participate or present testimony before the Board of Trustees. As you are very well aware, the applicant Palindrome Communities, LLC, requested and was granted of the board for authorization to present additional factual information and witnesses as permitted in accordance with Section 9.2.25, parentheses H, parentheses 3, parentheses D. Appellant requested the inclusion of additional documents. That matter was heard July 12, 2023, and approved by this body. I understand appellee would also like to supplement the record to include all pleadings filed in all cases pending between the village and Friends of Los Ranchos. Do I have a motion and a second to approve inclusion of all pleadings filed in those district court dockets? Before I call for the question, I would like to state that in my opinion, I believe the Board of Trustees has everything they need for a decision tonight, but it's up to the Board of Trustees to decide if they want to allow additional. Therefore, I'm going to call for the question, call for the roll call vote. Trustee Pacheco.
Do we have to have a motion first, Mayor? Yes?
Yes, I need a motion and a second. Go ahead.
I'd like a little clarification. So the motion would be to allow additional documentation from what we've received so far?
Let me read it to you.
Okay.
It's right
Please.
here in this paragraph.
Okay, please.
And whoever wants to make the motion, I will hand this to you and you can just read
Okay,
it.
okay, thank you.
Here's what it says. Appellant requested the inclusion of additional documents. That matter was heard July 12, 2023, and approved by this body. I understand appellee would also like to supplement the record to include all pleadings filed in all cases pending between the village and Friends of Los Ranchos. Do I have a motion and second to approve the inclusion of all pleadings filed in those district court dockets? So if you want to make a motion, you can read from there. Go ahead.
talks about,
Go ahead, sir.
Matt Beck on behalf of Friends of Los Ranchos, Mayor, Trustees. Since this talks about the appellee's request, I've got two comments for that. The first comment is that what is in the paragraph you just read is not accurate. We submitted a request for a specific set of pleadings to be included, and they were not.
Okay.
The second is the point of order addressing the emergency motion to disqualify, which goes hand in hand with the problems that you're facing now about what is in the record you just read and what is not in the record. And
That
so
will
I
be
think,
answered momentarily.
and so I think that that is the first order of business we should do. And then second, I can clarify with the exhibits attached to that emergency motion,
No, sir.
what exhibits the appellees are asking for.
I understand, but the question you're asking will be addressed in just a short manner. Right now, we're on that particular point. I need a motion and I need a second, and then I'm going to call for the question.
I'm not ready, 'cause
I'm not either.
yeah, I don't fully understand what.
Okay,
I
so,
thought we,
well, first of all,
July.
you can also always vote no. You don't have to vote yes.
but we in July, I think it was, we said both sides could include everything they wanted to include.
Perhaps I should go to our council. I want to introduce Kathleen Agger. Kathleen, because there's a question from the Board of Trustees about what the motion should say, do you need some time to prepare that motion or not?
It appears that the appellee,
Can I remind everybody real quick, please make sure you're talking into your microphones, especially when you're looking at each other.
Sure.
It's for the record,
Sure.
so we won't get a good recording of it if we don't.
Mr. Mayor, Mr. Beck has just stated that he did not intend to have all his documents included and all the documents that are in the dockets with the courts. He has specific information that he wanted to be included in the record. Your present language, it seems to include all documents.
Correct.
So it would include whatever, I would assume, whatever documents he wishes to have in. He has made a request for the complaint for declaratory judgment in case 2022-05-403. He's asked for their motion for summary judgment and exhibits for the motion for summary judgment and the village's motion for summary judgment response, including their exhibits. So the motion to include all documents would include the documents that they have requested to be included into the record. So it's up to you how you want to phrase your
Correct.
actual motion. By choosing to do the motion of all documents, you will include all their documents that they're requesting.
Does that answer the question, Trustee Lewis?
Sorta.
Okay.
So in July, we said both sides submit
Correct.
everything.
Correct.
And so now they're coming before us and we submitted everything, but now we want to submit more. Am I understanding that correctly?
I believe that's what the request is.
Now, you will be voting on this, so you can make a motion, and there can be a second, and then I'll call the question, and then you can decide.
Mayor, can I ask a question?
Of course.
So if a motion is not made, it dies.
It dies.
For lack of,
It dies. If there's no motion, no second, it dies. That item on the agenda, under Robert's rules, it dies. So I'm going to give you a minute, and if I get no motion,
Let me ask a question. So do we not have all the documents
I believe we do.
requested
I
in
believe
front of
we
us?
do. Even though he says no, but I believe we do. Okay,
Yeah, I'm a little uncomfortable accepting documents that we don't have in front of us.
and I agree with that,
Yeah.
quite frankly. Being no motion and no second, this item dies. I'm going to move on to the record, which includes documents and documents 1 through 46 as listed at the end of the planner's report. Copies of the planner's report are available at the front table. I'm not going to read it all. It's in the books that everybody has up here at the Board of Trustees. Now I'm going to move into what's called ex parte communications. When an application or other request is placed on the agenda for a regular or special meeting, it becomes a matter within the jurisdiction of the Board of Trustees and subject to the legal restraints on ex parte communication with trustees. I understand ex parte communications could compromise the fair and open purpose of these rules for the transaction of business. If the governing body believes he/she has been contacted ex parte on this matter, it is his/her obligation to so inform the other members of the Board of Trustees and the village attorney prior to the matter's consideration. And if the ex parte communication was in writing, submit it as part of the record for the meeting. Given this, is there any member who wishes to make such a disclosure at this time?
Only the disclosure that I already made, which I would consider a potential ex parte.
Thank you, Trustee Benavides. Please,
I have none at this time.
Trustee Pacheco,
I have none.
and I have none. Trustee Benavides, please do so now. State the name of the contacting party and when they contacted you, if you have that information.
It was an email sent by Mel Eves to all trustees.
Thank you. Two final matters before proceedings to the merits. I want to introduce Kathleen Agar, who I already introduced, with the Moses Law Firm. She will be assisting the governing body in this process. I also understand we received a late motion from appellee to disqualify this body and village council and a request to defer this appeal. Understand we have received this yesterday or maybe this morning. This is an administrative appeal, noticed up as an appeal. Our rules do not contemplate a motions practice. We will not be considering the motion this evening, but appellee is welcome to include the merits of the motion in any subsequent appeal of this matter to the court. Before proceeding, I have one closing comment, and this goes without saying. Again, please be polite and respectful to everyone who comments tonight. Thank you. So I'm gonna go A, B, and C before I get to the presentations that are gonna begin. Item A, appeal to SDP 23-01. An appeal of the May 18th, 2023 Planning and Zoning Commission Notice of Decision recommending that the February 15th, 2023 village approval of the Site Development Plan, SDP 23-01, be vacated. The subject property is Zone VC, Village Center, and is in the 4th Street character area. The property is located at the southeast corner of 4th Street Northwest and Osuna Road Northwest, and is legally known as Tract 1. Trailhead at Chamizal Subdivision, Los Ranchos de Albuquerque, Bernalillo County, New Mexico, as filed in the office of the Bernalillo County Clerk on August 25th, 2022. The property contains 1.6096 acres, more or less. Item B, appeal to SDP 23-02. An appeal of the May 18th, 2023 Planning and Zoning Commission Notice of Decision recommending that the February 15th, 2023 village approval of the Site Development Plan SDP 23-02 be vacated. The subject property is Zone VC, Village Center, and is in the 4th Street character area. The property is located at the southeast corner of the 4th Street Northwest and Osuna Road Northwest, and is legally known as Tract 2, Trailhead at Chamizal Subdivision, Los Ranchos de Albuquerque, Bernalillo County, New Mexico, as filed in the office of the Bernalillo County Clerk on August 25th, 2022. The property contains 1.9075 acres, more or less. Appeal to SDP 23-03. an appeal of the May 18th, 2023 Planning and Zoning Commission Notice of Decision recommending that the February 15th, 2023 village approval of the Site Development Plan, SDP 23-03, be vacated. The subject property is Zone VC, Village Center, and is in the 4th Street character area. The property is located at the southeast corner of the 4th Street Northwest and Osuna Road Northwest and is legally known as Tract 3, trailhead at Chamizal Subdivision, Los Ranchos de Albuquerque, Bernalillo County, New Mexico, as filed in the office of Bernalillo County Clerk on August 25th, 2022. The property contains 1.8761 acres, more or less. Ms. Simon or Ms. Winter, will you please present the appeals? Thank you.
Thank you, Mayor and trustees. I am going to point out a typo that appears on the front page of our report. This is an appeal of the May 9th, 2023 Planning and Zoning Commission. The Planning and Zoning Commission met and ruled on May 9th, not May 18th, and that carries for STB 2301, STP 2302, and STP 2303.
Thank you.
And I am going to turn it over to Ms. Winter to present the report.
Thank you, Mayor, trustees. The planning report tracks essentially the format of the planning report received by Planning and Zoning on May 9th, 2023. It's a part of the record, a part of your packet. It summarizes the locale and legal description of the property, the background of the property and the project. It also summarizes the law as presented to the Planning and Zoning Commission on May 9th of 2023, and as subsequently further developed in correspondence between the parties. It also goes point by point, addressing the appellant's points, and I believe there are 8 or 9 of those. From pages 9 through pages 12, it goes point by point addressing appellant's points. Ultimately, the department recommended that Palindrome's appeal be granted. The findings, proposed findings, recommendations are also attached and included in the planning report. Thank you.
Thank you. It is.
I've got a question.
Go right ahead, please.
I heard that planning report is part of the record. It's not in the binders, and we did not get a copy of that. So if we could have a copy of that for tonight's hearing, that would be
Danielle, would you make a copy and please provide it to Mr. Beck? Thank you very much, Mr. Beck.
Mayor,
Yes.
trustees, the planning report was provided to Mr. Beck and Mr. Eves and Mr. Campbell at the same time in the same email on Friday afternoon.
Thank you. We're going to make it available to him again. Okay, it is now time for the applicant to present their case. Will anyone that plans on presenting or testifying please stand up and be sworn in? Please remember that pursuant to the rules of appeal, only those speaking at the Planning and Zoning Commission may comment or testify this evening, and those that were approved at the July 12th, 2023 Board of Trustees meeting are permitted to participate. Mr. Campbell, let's go ahead and let's see. Are you going to swear them in right now?
I am.
Go right ahead.
Anyone who is speaking this evening, please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? I do.
Okay, Mr. Campbell, please approach the podium. Please state your name and address for the record. You have a total of 45 minutes for your opening and presentation of witnesses.
Mr. Mayor, trustees, my name is David Campbell. My address is P.O. Box 20280 Albuquerque 87154, and I represent Palindrome Communities, the appellant here. This hearing is the Board of Trustees' opportunity to consider and approve the site development plans for phases 1, 2, and 3 of the Trailhead at Chamizal Village Center Development Project. Let me begin by saying what this hearing is not. This is not a hearing about whether landscape architect George Radnovich should have placed his signature on an application for this project. We are here, and architect Radnovich has properly recused himself from this meeting and from his role as a public official. Mr. Radnovich is a professional member of the team that was awarded this contract by the village years ago at an open meeting. Friends of Los Ranchos has already sued the village on this theory. This is also not a hearing about whether there is a properly noticed public hearing before the governing body. This is a properly noticed public hearing before the governing body. Friends of Los Ranchos has already filed an Open Meetings Act lawsuit against the village on that topic. This is not a hearing about whether the Village Board of Trustees properly entered into a purchase, sale, and development agreement with Palindrome. That public meeting was held in these chambers nearly 3 years ago, in October 2020, and was not appealed by anyone within the required time frame or at all. Friends of Los Ranchos has already filed a lawsuit against you, the village, on this theory. This is not a hearing about the Metropolitan Redevelopment Act or the state's anti-donation clause. Those public hearings were held 16 years ago in this room when the late Mayor Larry Abraham of blessed memory sat in that chair, Mayor Lopez. Friends of Los Ranchos has already filed at least one lawsuit against you, the village, on that theory. This is also not a hearing about whether the VC Village Center zone should be changed. The last changes were made in a public meeting in this room 7 years ago this week, when Mr. Craig, the head of Friends of Los Ranchos, was on the Planning and Zoning Commission and voted to approve the Village Center zone amendments. And finally, this is not a hearing about whether people of all income levels can reside in these apartments. Discrimination on the basis of income or ethnicity is not allowed in making zoning decisions and runs counter to America's long-held principles of equity, equality, and fairness. Honorable trustees, this is a hearing for you as elected officials to consider the previous administrative approvals of these 3 site development plans and to consider the site plans, any objections to the site plans, and then to modify or approve them. The site plans were approved 6 months ago. The approval by the village was in full compliance with the purchase, sale, and development agreement between the village and Palindrome, a document that has been a binding contract for 3 years between this municipality and my client. Both Palindrome and the village have relied on this contract and have properly and appropriately spent millions in accomplishing the goals and objectives of that contract, which was approved, as I said, 3 years ago in an open meeting in this room and never appealed by Friends of Los Ranchos or anyone else. The site plans were just one of a series of approvals that the village has made in this project. In addition, there has been sketch plat approval, a traffic impact study, a preliminary plat approval, a final plat approval, grading and drainage approval. Additionally, Bernalillo County has fully approved the building permits for the project, and the construction is being monitored and inspected by Bernalillo County every single day at the site, some parts of it for over a year. Construction of the trailhead at Chamisal is well underway, and millions of dollars have been spent on the infrastructure and buildings on that site, all in accordance with the legal and proper decisions that have been made along the way by this municipality. The site plans are before you. In the May 9th Planning and Zoning hearing, the Friends of Los Ranchos did not complain once about any issue regarding the site development plans. Rather, they complained mainly about they had not appealed the purchase, sale, and development agreement in October of 2020 when this Board of Trustees approved it. Even tonight, Mr. Craig's lawyers will tell you how much they wish Mr. Craig had appealed that development agreement 3 years ago, but did not. I have with me tonight 3 witnesses, 2 of whom know the site development plans intimately since they have been involved from the start. The other witness, Tim McDonough, is well known to you as having been a trustee, a planning and zoning director, and a village administrator. Without further ado, I'd like to call my first witness, Mr. Mayor, and that is Hannah File Greenhood, architect. Hannah, would you come forward?
Is it on? Can you tell? Push the button. I don't think so. You gotta push the button.
Oh, can you hear me?
There we go.
You can bring this down.
Would you please state your name and address and your profession for the record?
Sure. Hannah File Greenhood. I'm a licensed architect here in New Mexico, and I am currently working for Decker Parrish Sabatini.
Ms. Greenhood, did you perform work on the Village Center project?
I did.
And what was the work you performed on this project?
Our firm has been involved since the beginning with the master plan, and all the way through till now, we've been a participant in the site development plans. We've also been a participant during building permit process and all the way through construction.
Okay. So you did work on the site development plans for this Village Center project?
Yes.
Thank you. During the course of your work on the site development plans, did you interact with personnel at the Village of Los Ranchos, including the planning and zoning director?
I did. Yes.
And in those interactions, did the planning and zoning director direct you to make any modifications to your architectural or design plans in the site development plan?
Yes.
And just sort of anecdotally, if you could, first of all, did you make those changes?
Yes, absolutely.
And do you recall, say, one of those changes that may have been requested by the village and can tell us about that?
Sure. There's a handful of them. We go through a review process and have to respond to review comments. One, top of mind as an example, is parking space sizes. Parking space sizes, according to the Village of Los Ranchos, are required to be 20 feet deep. There are other jurisdictions that allow you to do an 18-foot deep parking space and then overhang 2 feet, therefore making 20 feet. We tried to do that, and the Village of Los Ranchos did not allow us to do so. So we made that correction, and all parking spaces are 20 feet deep from back of curb.
Great, thank you. So in designing the Village Center site and the structures, did you follow New Mexico law?
Absolutely, to the best of my ability.
And local building codes, did you follow them?
Yes.
And did you adhere to accepted practices in the profession of architecture?
Absolutely.
Let me ask you, is there an alternative parking plan to address all required parking on the site?
Yes. So there's some language within the zoning ordinance that allowed for an alternative parking plan. This allows us to look at all 7 sites that make up the larger village center and accommodate for total parking counts and other qualifications to lead to a total parking plan. And that had to be approved by the authority having jurisdiction.
Okay. During or since your work on the site development plan, have you been made aware of any mistakes or failures of your work or your firm's work on the project, including any incorrect calculations or design flaws?
I have not been made aware of that.
Okay. And during or since your work on the site development plan, have any Friends of Los Ranchos, members or attorneys contacted you?
Not personally. We have had a couple open houses and neighborhood interactions, but nothing directly, no.
Okay. And would you say that anybody from the Friends of Los Ranchos has raised any substantive architectural issues with you?
No.
Okay. And now, bringing it forward to today, have you continued to monitor the construction of the Village Center project?
Yes, we have a dedicated team of construction administrators that visit the site weekly, sometimes more than that, depending on what's needed. We meet weekly on OAC meetings.
Ms. Greenhood, thank you very much. You can sit down.
Thank you.
You may be called back up if opposing counsel has any questions, or the trustees. Now I'll call Mr. Graham Means, engineer. Mr. Means, would you state your name, profession, and your address?
My name's Graham Means. I'm a civil engineer with High Mesa Consulting Group. Our address is 6010B, Midway Park Boulevard, Northeast Albuquerque.
And Mr. Means, did you perform work on the Village Center project?
Yes, I did.
And what was the work you performed on this project?
In my capacity as a civil engineer, I provided grading and drainage plans, roadway plans for the interior, and also for modifications in Osuna and 4th Street. Also prepared, did I say water and sanitary sewer plans?
Okay.
Yeah.
And did you work on the site development plans for this Village Center project?
Yes, we provided the grading and drainage plans that were part of that. I also coordinated with the county fire marshal to get the approved fire plan that has the fire flows and the hydrant locations, and also used that to work with the Albuquerque-Bernalillo County Water Utility Authority to get the water and sanitary sewer serviceability statement. That was also part of the site development plan.
Okay. And during the course of your work on the site development plans, did you interact with personnel at the Village of Los Ranchos, including the planning and zoning director?
Yes, I interacted frequently with Tiffany Justice, the planning and zoning director, with Ann Simon, the administrator, and also with Maria Rinaldi about infrastructure and storm drainage issues.
And in the course of that, did the planning and zoning director or any of these personnel direct you to make modifications to the site development plan?
The modifications to the site development plan did not come directly from the village, but through their consultant. They have an engineer, Bohannon Houston, reviews their grading and drainage plans. So every time I submitted a grading and drainage plan, it was forwarded to Bohannon Houston for review. And then they would provide comments back to Tiffany or Ann, and then they would forward them to me.
So just to underscore that, the village had its own consulting engineer with whom they communicated and checked the work that you were doing. Is that right?
Yes, there was, I think we ended up having 3 submittals with back and forth and addressing comments.
Okay. In designing the Village Center site and its engineering, did you follow New Mexico law and local building codes?
To the best of my knowledge and belief, yes.
And did you adhere to accepted practices in the engineering profession?
Yes.
During or since your work on the site development plan, have you been made aware of any mistakes or failures of your work or your firm's work on the project, including any incorrect calculations or design flaws?
I have not.
Okay. And during or since your work on the site development plan, have any friends of Los Ranchos, members or attorneys, contacted you?
I did have someone come to my door with a petition asking me to sign that.
Okay. But not in your capacity as an engineer on the project?
No, as a village resident.
Okay, all right. And have you, bringing it to today, have you continued to monitor the construction of the Village Center project?
Yes, we have construction phase services. Matter of fact, I had an engineer out there this morning.
That recently. Thank you very much. Mr. Means, thank you very much for your testimony. Again, you may be called back up if there's cross-examination or if the trustees would like to ask questions. Thank you. I'd call now Mr. Tim McDonough. Mr. McDonough, would you state your name, your address, and your Village of Los Ranchos positions that you've held over time?
Yes, my name's Tim McDonough. I live at 1024 Ortega Road Northwest in the village. I was elected trustee in 2004. I served until 2013 when I stepped down to become the planning and zoning director. So I was planning and zoning director then for 7 years.
Okay. And are you familiar with the Village Center project?
I am.
And what has been, if you could just elaborate, what has been your involvement with the Village Center project through any of those roles that you've had with the village?
So starting in 2004, the first ordinance was passed in 2002. So we looked at it several times, made some amendments to it, discussed what we wanted in that, made a number of decisions having to do with process, land acquisition, developers, RFPs, so pretty extensive.
Okay. And you mentioned the RFP. Were you on the committee that reviewed the RFP proposals for the Village Center project?
I was.
Okay. And was it that committee that recommended Palindrome Communities as the contractor on the project?
It was.
Thank you. And did you agree, as in either of your roles, either as trustee or planning and zoning director, that the southeast corner of 4th and Osuna was suffering from blighted conditions prior to the village's declaration of blight under the Metropolitan Redevelopment Act?
I did agree.
What was your involvement with the Metropolitan Redevelopment Area Plan for the Village Center project?
I had a fairly minimal involvement in the plan, in the Metropolitan Redevelopment Plan. That was handled primarily by Maria and our attorney at the time, Bill Chappell.
Okay. And did you work in the administration of Mayor Larry Abraham?
I did.
What do you remember about Mayor Abraham's thoughts or plans on the corner of 4th and Osuna?
Mayor Abraham was very concerned about the health of the commercial area and the businesses in the village. That was really a big focus of his. And he discussed several times, the 4th Street improvements and the village center, which one should go first, what's the best way to support the businesses, and then later discussions about people that would come to him, older people that were on big properties that wanted to downsize, but they didn't want to leave the village. So he had that concern as well.
Was Mayor Abraham in favor of residential development in the Village Center project?
He was.
In your experience, I'm hearing some comments, and I'd appreciate if we follow the protocol, Mr. Mayor.
Be polite and please allow the speaker to speak comfortably with no interference. Thank you.
In your experience, were there multiple public village open meetings at which the Village Center project was discussed?
Oh, there were numerous meetings.
Can you say more about that?
Yes, so it began with the first amendment, I think, was 2007 to the original 2002 ordinance. And once we had that established, we started looking at property acquisition. And every time we acquired a property, that became before the Board of Trustees in a public meeting, discussed the value, what we were going to pay, and there had to have been 10 or 12 of those. Then it got into the process. It got into the Metropolitan Redevelopment Plan and the solicitation for a developer, selection of a developer, and then negotiation of the agreement, the development agreement.
Okay. Do you remember Mr. Joe Craig as having any involvement with the Village Center zone or other aspects of the Village Center project?
Yes, he sat on the Planning and Zoning Commission.
Okay. Sat on the Planning and Zoning Commission? Okay.
Yes.
Do you recall Mr. Craig's participation in Planning and Zoning Commission when the Village Center project zoning was being amended? Do you remember that?
I do.
And did you attend the August 29th, 2016 meeting of the Planning and Zoning Commission as director of the Planning and Development Department?
I did.
And let me ask you, this is Exhibit 45, which you have in front of you, Exhibit 45 in the record. Do you recall whether Mr. Craig objected to any statement in the village center zoning that said that the village center zone should be the highest density residential zoning district in the village of Los Ranchos?
I don't recall him objecting to that, no.
And there's a statement in the current village center zone that says that the village may control development parameters by requiring economic development plans or entering into development agreements. Do you remember, or does the record reflect any objection that Mr. Craig had to entering into development agreements?
No.
Okay. Thank you. Mr. McDonough, thank you for your testimony today. You may be called back up for cross-examination or for questions by the Board of Trustees, but I thank you for being here.
Mm-hmm.
Honorable trustees, the 3 approved site development plans are before you tonight, here in an open meeting. They are in the record as exhibits 34, 35, and 36. The applicant and developer and your development partner in the 3-year-old purchase, sale, and development agreement is here tonight and available to respond to questions about the site development plans. Mr. Reniker, Mr. Glass are both here. Additionally, you have heard from the architect and engineer who developed those site development plans. They are available for cross-examination or for questions from this governing body. In its May 9th meeting, the Village Planning and Zoning Commission did not raise substantive issues, any substantive issues, about the site development plans themselves, but seemed to make their decision on whether the public meetings had been held. That P&Z Commission hearing was a public meeting, and this is a public meeting. Today is the day. This is the public hearing. These site development plans were properly approved in accordance with law and the agreement between Palindrome and the Village of Los Ranchos. These site development plans represent the culmination of decades of planning for the village center. The record before you discloses that this project has been subject to dozens, if not hundreds, of public meetings and hearings. It is featured in the village master plans going back to the early 2000s and was a dream of every mayor and board of trustees since Mayor John Hooker and Mayor Larry Abraham. The Metropolitan Redevelopment said that this was a solution to remedy the blight at this site. The zoning code says this will be the most intensive residential area in the entire village and would be a gathering place for residents and villagers alike. For residents and visitors alike, excuse me. The state of New Mexico and Bernalillo County have invested millions in this project, along with Palindrome, because they want to be part of this visionary development so many years in the making. The site development plans are before you tonight for approval. They are important technical documents, as you heard from the architect and the engineer. They deal with hydrology, traffic circulation, landscaping, curbs and gutters, and building footprints. They were properly approved over 6 months ago, and we have yet to hear why the Friends of Los Ranchos object to the site development plans. But as I said earlier, tonight is the night. This is the public hearing. The Friends of Los Ranchos and their lawyers are here to tell us why they object to the site development plans. Now we're ready to hear what problems Friends of Los Ranchos has with these approved site development plans. Mr. Mayor, trustees, thank you.
You're welcome, Mr. Campbell. Thank you very much, Mr. Campbell. At this time, Mr. Matthew Beck, please approach the podium. Please state your name and address for the record. You have 15 minutes for cross-examination of all of Palindrome witnesses. This is not a time to argue, but instead cross-examine. Please proceed.
I think lawyers would tell you that cross-examination isn't the time to argue. My name is Matt Beck. I am at 20 First Plaza, Suite 725, Albuquerque, New Mexico, 87102. And I'll call back up Ms. File Greenwood, if I heard that correctly.
I think the mic is on.
Is this still on? Okay.
Yes.
Is it Ms. File Greenwood or Ms. Greenwood?
File Greenhood.
Ms. File Greenwood, thank you. I heard from your testimony that you've been involved, or you've worked on this, including with the master plan, right?
Correct.
Is that the 2020 master plan or the 2035 master plan?
I don't have that information off the top of my head.
Okay. Do you remember when working with the master plan that the only time it mentions the Village Center project is in connection with economic development and commercial development?
Could you repeat that question one more time?
Do you remember when looking at the master plan, the only time it mentions the Village Center project is in economic development in connection with commercial development?
I don't recall that specifically, but I also would like to review that separately to be able to answer that.
I'm sure you'll have time with Mr. Campbell. You worked on the site development plans,
I did.
and you interacted with the planning and zoning director, is that right?
Correct.
Have you worked on site development plans for any projects other than the Village Center in your career?
Yes.
Working on the Village Center project site development plans, did you interact with the Board of Trustees?
I did not.
Did you interact with the Planning and Zoning Commission?
I did not personally.
Did you attend the Planning and Zoning Commission hearing when they heard the site development plans?
I did not.
Did you attend the Board of Trustees hearing when they approved the site development plans?
I did not.
Are you aware that the village ordinances require that both the Planning and Zoning Commission and the Board of Trustees hear those site development plans before they are approved?
I'd have to review the procedures for that. I'm not quite sure.
Okay. For other projects you've worked on, have you ever been called to testify before a public body about your work on any kind of project?
No.
All right. No further questions. Thank you. Mr. Means, I'm not sure if I heard that right. Mr. Means, I heard you say that someone came to your door with a petition against this project. Is that right?
Yes.
Did you sign it?
No,
Why not?
because I told that neighbor at the time that it was my opinion that people should be able to do with their property what they wish in accordance with the zoning regulations.
Okay. Did you tell him you thought it was a good project?
I didn't tell anything about the project.
Do you think it's a good project?
Are you allowed to ask me that?
I just did.
Yes, I think it's a great project, I think,
Why do you think that?
because it provides economic benefits to the village. I've been a village resident since 2000. It would provide opportunities to keep tax resources, gross receipts tax will benefit me personally as a village resident and the village as a whole. In the future phases, there's going to be community gathering spaces. There's going to be a performance area. There's going to be a community farm. There's going to be exhibition areas. Also, there's planned hotel, which I'm looking forward to the pizza kitchen and the microbrewery that I see will be in there. And also, it's an opportunity for when I have friends and family visit that they can stay somewhere closer to where I live.
Okay. Do you think it's important for the Board of Trustees to hear why you think this is a good project?
I really don't.
You don't think it's important for the Board of Trustees to hear why you think the Palindrome project is a good project?
I don't think it's relevant to the technical aspects of appeal of a site development plan.
Well, I'm not asking whether it's relevant to the technical aspects of site development plans, I think you said. I asked if you think it's important that the Board of Trustees get to hear why you think this is an important project, great project for the village.
I really don't know how to answer that question. I don't know what you're looking for.
Have you attended Planning and Zoning Commission or Board of Trustees hearings where other projects have been in front of the village where you did not work on them?
No, I haven't.
And so you haven't heard people speak in opposition before the Board of Trustees or the commission what aspects of a project they agree with and what they don't agree with. You've never heard that, have you?
No, I haven't.
But you know what goes on.
Yes, I've read newspaper articles and seen website articles, and
And you know that this project is a major subdivision, right?
I don't know that.
Okay, you don't know your work in the site development plan, that it's part of a major subdivision site development plan?
No, I don't know that it's major or the classification.
And you don't know, do you, that this is the only major subdivision site development plan that has not gone before the Board of Trustees with public comment before it was approved by the village? You don't know that, do you?
It's my understanding, and then I believe I saw that in a comment letter for the site development plan, that the planning director repeated the language from the development agreement that said that this is why this is an administrative process.
My question was a little bit different than what you saw written. My question was, you don't know, do you, that this is the only major subdivision site development plan ever that has not come before this Board of Trustees for a public hearing with proper public notice beforehand before it was approved by the village?
I certainly do not know the history of every case that's come before the village.
You don't know of a single one that's come before the village without Board of Trustee approval, do you?
No, I have not worked on a project that has gone before the Planning and Zoning or the Board of Trustees, and I don't have any personal knowledge of the details.
Thank you, that's all I have. Mr. McDonough. Mr. McDonough, you've got a lot more experience, so I hope I can get this done in 7 minutes and 36 seconds with you. You've been an active participant in the village going back almost 20 years. Is that right?
That's correct.
Including as the Planning and Zoning Director for 7 years.
Correct.
As the Planning and Zoning Director, I'm sure you had to work with, on an often basis, if not daily basis, the village ordinances in Chapter 9, Articles 1 and 2, right?
Yes, that's true.
And you know that as the planning, plotting, and permitting and zoning ordinances for the village, right?
Yes.
So you know that under those ordinances, in Ordinance 9.1.8, final plot plan approval for major subdivisions has to go before the commission and the Board of Trustees before approval, right?
I think that speaks to a typical major subdivision, and this is not a typical major subdivision. This is a development under the Metropolitan Redevelopment Act, which has a different set of rules. It's a public-private partnership, as it's called.
I think you said typical. If I look at Section 9.1.8, and I'm happy to give you a copy if you'd like. Under the village code, could you point out for me where it says that this applies to, quote, typical major subdivision projects in here? Go for it. And I'll tell you that it's not in there, but you can look.
Okay, I'll take your word for it.
All right. Right before that 9.1.7C, it talks about major subdivision plot approval that's required by the Board of Trustees. Does that section include, I think as you said, quote, typical? And again, I'll tell you it doesn't.
Okay, and so understand, we're a small village. We're not the city of Albuquerque. And you can go through all of our ordinances, and you can find little discrepancies where, when they wrote these, they envisioned a typical residential subdivision, right? And we've had a lot of major subdivisions that have all followed this path. This is not standard for this community. This is the first time we ever did this. So we
Hold
were
on one
breaking
second.
new
Hold on.
ground.
You can finish that with Mr. Campbell. This is the first one that's not followed that process. You agree with me on that? This is the first ever project in the village for a major subdivision that has not gone before the commission for a properly public hearing, properly noticed, and then before the Board of Trustees for a public hearing that was properly noticed, right?
So it has gone before both of those bodies in many forms. Was the site plan, did that follow the path? No, because of the development agreement that specifically said it would be handled differently. That was approved by the Board of Trustees in a public meeting.
And do you know whether a development agreement can, this is my language, it's not legal, trump state laws and village ordinances?
I don't know of any state laws that this trumped, but the village ordinance that allows for village centers specifically says that other than the village center project, all other projects would follow 9.1.25. It specifically excluded the village center project in anticipation of a negotiation with a developer who was going to finance this.
I think you mean 9.2.25, right?
Could be.
And
It's been a while since I sat in the office.
9.2.25 also is the only village ordinance that governs appeals. Agree with me on that?
I couldn't answer that.
Okay.
I don't know them that well.
You said that, let me think back to this, give me a second here. You said that, thank you, thank me. You said that you didn't remember any, you don't know of any state laws that this development agreement trumped, right?
Well, I don't know what you mean by trumped. Violates?
Violates.
No, I don't.
Okay. Stick around.
But then I don't
stick
know
around,
state law.
Please let me finish my question, then I'll let you finish your answer. Stick around to the end of the night, and you will see lots of state laws that this development agreement violates. In your time as trustee or planning and zoning director for what I think is 16 plus years, if I have that right, did you ever see a major subdivision preliminary plot that did not go before the Planning and Zoning Commission and Board of Trustees before it was approved?
I think I maybe only saw one major subdivision in my time. And no, is the answer you're looking for.
In your time as trustee or planning and zoning director for 16 plus years, did you ever see a final plot for a major subdivision that did not go before the Planning and Zoning Commission and the Board of Trustees at a properly noticed public hearing?
A final plat or a plot?
Final plot.
I don't know what a final plot is.
Is it a plat?
Yes.
Okay, a final plat plan.
Yes, because the way it is structured, the preliminary would go before both bodies, but only required to go to planning and zoning unless the trustees asked for it to be brought back for a final approval by the Board of Trustees.
And the way it's structured, you're talking about 9.1.7, 9.1.8.
I can't quote those numbers. You've been working on it longer than me.
Well, I know that's not true. When you talked to former Mayor Abraham and he was in favor of residences in the village center, did he say he was in favor of over 200 apartments in the village center?
We never had that level of a discussion.
Thank you. That's all I have, Mayor, Board of Trustees.
Thank you very much. It is now time for the trustees to ask the appellant or the applicant questions. We will have each trustee ask their questions before moving on to the next trustee. Trustee Pacheco.
Mayor, trustees, I don't think I have any questions right at this moment, but I would like to, to keep my time to be able to ask questions as those develop.
Absolutely. Trustee Lewis.
I don't have any questions at this time.
Trustee Benavides.
Yes, can we include Attorney Nan Winter in the questions?
Is that okay, Kathleen? Yes.
So to Attorney Nan Winter, what are the consequences of not making a motion to approve or deny this appeal by Palindrome?
Mayor, trustee, can you repeat the question, please?
Yeah. What are the consequences if we do not make a motion to approve or deny the appeal by Palindrome?
I think you're asking a procedural question that maybe is more fitting for Kathleen. I think you're asking, and just so Kathleen can get to it, you're asking whether or not at the end of this hearing, there would be no motion,
Yes,
one way
and
or the other.
I could, maybe I could ask it later, but what I'm getting at is I think what we see happening just continues to happen with the development. Would that be true? Nothing stops, right?
Mayor trustee, I'll kick that to Kathleen to answer the procedural, and then maybe Mr. Campbell can answer what happens to the project if this is unresolved.
I mean, a similar question, because everything seems to pivot on the legality of the development agreement, which is something that is going to go before district court. So I would say, what are the consequences of deferring the appeal until after the settlement of the lawsuits in district court?
Do you want to answer that, Kathleen, or would you like Mr. Campbell to step in? And of course, he can talk because this is for either the applicant or the appellant. So go ahead, Mr. Campbell. We'd like to hear the answer to this question.
Trustee Benavides, if I understand your question, it is, what if this Board of Trustees does nothing tonight?
Correct.
Is that right? Are you saying,
Correct.
what if you do nothing?
Yes.
I think what that means is that you have not you've not acted to get finality on this. And if I understand the second part of your question, it is that you would rather not do anything and let somebody who is down at 4th and Lomas make the decision in lieu of this governing body making that decision. And to me, that's an abdication of the responsibilities that you have as elected officials. To simply say, and with all respect, I've served as city attorney.
Please keep the chatter down, please. We want to hear. Go ahead, sir.
I've served as city attorney of the city of Albuquerque, and part of the duty that municipal elected officials have is to make decisions, and then if those decisions are second guessed or if they're appealed, then that person down at 4th and Lomas can make a different decision. But without a final decision, without finality out of this municipality, then there is no ability for, and we expect it, there is no ability under Rule 74 for the Friends of Los Ranchos to then file their inevitable appeal of your decision down at 4th and Lomas. So it's not by not doing anything that you get a judge to decide this. It's by doing something that you actually get a judge to decide this. And frankly, that's what's being played out here. I mean, earlier you heard motions to vacate the hearing and to forget about, this is a municipal affair. This is something that the city needs to make, the village needs to make a decision about. And only then can your question be answered, and that is only then can a district court say yay or nay on the appeal.
Well, while you're there, do you believe that the Village of Los Ranchos already violated the purchase, sale, and development agreement with the appeal by Friends of Los Ranchos?
Do I think that the village violated the purchase, sale, and
Because that
development?
decision to uphold the Friends of Los Ranchos appeal at P&Z, did that already violate our development agreement?
I don't believe so, and I'll use the word inchoate. That decision by the Planning and Zoning Commission was a recommendation to this body, to the body of elected officials, and it was not a final decision in and of itself. I will also say that this whole talk about purchase, sale, and development agreement that was executed in this room by this body and then signed by Palindrome was done 3 years ago, October, so nearly 3 years ago. And on the basis of that agreement, that contract, there has been a great deal of movement. And that because, and this relates back to your other question, until there's finality, until the PSDA was actually passed by this body, it could not have been appealed to district court. But once it was passed in October of 2020, it could have been appealed to district court. And that's the place that Mr. Eves and Mr. Beck want to be. They would like to be 3 years ago where that was appealed and they could have made their administrative or their objections to the administrative passage at that time. But now it's way, way, way 3 years too late to do that.
So if the Board of Trustees were to deny the Palindrome appeal, your appeal, which effectively would uphold the Friends of Los Ranchos appeal, would the Village of Los Ranchos then be violating the purchase, sale, and development agreement?
I'm not going to give you an opinion on that. I'm not. You have your own counsel to ask legal opinions of, and I will advise my client on issues, on legal issues, but I'm not going to purport to be your counsel on those kinds of questions.
So are you familiar with 9.2.14L of our code?
I am.
Do you believe that allows for a development agreement?
That has to be read in concert with 9.2.14, the third paragraph, that says that in this project area, the village will encourage the types of development envisioned and may control development parameters by requiring economic development plans, entering into development agreements, and to the extent the land may be owned or controlled by the village, by filing covenants and restrictions dealing with development and use of the land, in addition to the zoning ordinances. When you take that paragraph that's at the very top of the VC Center zone, and you combine it with subparagraph L that you just cited, which says, all applications for development requiring platting actions other than the project area shall be approved in the manner set forth in 9.2.25. So I won't get into sort of how lawyers or courts read or try to reconcile, but generally we try to reconcile language that's within the same law in ways that make sense. And what makes sense here is that by saying up front that you may enter into development agreements in the project area, and then you look and say that all applications for development requiring platting actions other than the project area, then you have a consistent interpretation and a wise application of this. I will also say that development agreements are frequently done in land use and development projects throughout this city, the state and nation.
So you're familiar with multiple development agreements?
I am.
So can you cite an example of a development agreement that would allow for the normal P&Z approval process to be circumvented?
So let me give you an example. I deal with development agreements with the Albuquerque-Bernalillo County Water Utility Authority. And the Water Utility Authority is governed by a board of elected officials. And those development agreements are frequently, almost uniformly, say that this easement, these water lines, these sewer lines will be administratively approved by the engineers in the Water Utility Authority. They rarely go to the elected body to decide where or how big the pipes are going to be. And that's very typical in development agreements.
But in particular, a site plan that would normally go through planning and zoning, are you familiar where that's been circumvented with a development agreement?
Yeah, development agreements, particularly those that deal in the metropolitan redevelopment area. And again, I was the planning director for the city of Albuquerque in addition to being city attorney. I'm not giving you legal advice, but I will say that yes, there are frequently situations that allow under metropolitan redevelopment for development agreements to be done that vary the actual terms of process and procedure.
Let me ask you this. If a palindrome appeal, your appeal, is denied, and palindrome is required to have their plats/plans reviewed by our P&Z Commission, and if no instances of noncompliance are found, and similarly, if it comes to the Board of Trustees, no instances of noncompliance are found by the Board of Trustees, and you are approved, then would you be satisfied with that?
I'm sorry. I'm here on an appeal of a decision of the P&Z. You're asking me some hypothetical questions.
Yes, I am asking you.
Yeah, I'm not going to answer hypotheticals.
So I know you rather skirt the issue of Trustee Radnovich, but his name appears probably in 100 different places in our notebooks, right, that we have before us. It's hard to avoid it. So was Trustee Radnovich paid for any of his service as an agent?
No, sir.
As a contractor for palindrome?
Mr. Radnovich, let me clear up something. This body entered into a proposal. You went out to RFP, and then you asked for proposals. And one of the team members on those proposals for this project was landscape architect George Radnovich. He's big as day in the proposal that was submitted to this body in an open meeting and chosen. Later, Mr. Radnovich became Trustee Radnovich, I believe in the same election when maybe you were elected. And in this case, for none of you does your service as a trustee on the Village Board of Trustees negate your ability to make a living. Nobody has said that you can't yourselves have a day job simply because you have this volunteer public official job. And that's what Mr. Radnovich is being accused of, is that he somehow cannot pursue his day job because he is a trustee on this board. And that is not the rule.
You know, Trustee Radnovich and I have been very critical of a lack of transparency to the administration and to the mayor as well. Do you believe that Trustee Radnovich was not transparent in disclosing that he was an agent of palindrome?
I don't believe there was any lack of transparency when, as you point out, his name is hundreds of times, you said, in these documents, including on exhibits 34, 35, and 36.
However, I had no knowledge that he was an agent of palindrome until recently, until there was a complaint filed by Friends of Los Ranchos. Let's see. I do have further questions for Attorney Beck.
That's fine. Mr. Beck, please approach the podium.
Thank you.
I'll start with you, and then I'll go backwards, just to see if there's any questions from the other trustees. You go ahead.
Oh, okay. Yes. Do you agree that 9.2.14L allows for development agreements?
I don't think L does. I agree that, I agree the other provision, I don't have it in front of me. There is a provision in there that allows for development agreements. I agree with that.
I mean, so there are many instances of our code which sometimes they appear to be contradictory, and then apparently what we do is look at the latest issue as what applies to the issue at hand. And so you pointed out some instances where a major subdivision should go through planning and zoning, but there is another part of our ordinance that would allow it to circumvent the planning and zoning. Do you disagree that that's the case?
I disagree that, Mayor, Trustee Benavides, I disagree that that's the case.
So if the Board of Trustees were to deny the palindrome appeal, which effectively upholds the Friends of Los Ranchos appeal, do you think we would be violating our purchase, sale, and development agreement?
I think there's two things to that answer. Mayor, Trustee Benavides, I think there's two things to that answer. Number one, no, because you cannot, it is illegal to bind the village in a code to do any sort of planning, plotting, or zoning. That is illegal. Number two, there are different breaches that I think both parties had done before this that would render both parties in breach of that agreement sitting here today. So I don't think doing anything on the appeal today will result in any kind of breach of the agreement as it's already been breached.
Do you believe that Trustee Ranovich also failed in being transparent in his association with palindrome?
I'm too new to this to know. From what I've seen that, as you pointed out, his name's all over the place. Every meeting I've been in, he's been out of the room for this, so I really can't speak to that.
Okay, I mean, he was a landscape contractor for palindrome, a member of the palindrome management team, worked on the RFP, as an agent for palindrome, as a consultant for palindrome, and yet you have no.
I mean, I think you'll see in our appeal, and we maintain the position here that is a conflict of interest. It is a violation of the Government Conduct Code, and it is not something that can be waived. It's imputed to the board, so I think that position is clear. You're asking me whether he's been transparent, and my explanation to you, Mayor, Trustee Benavides, is that I cannot say.
Let me go further. So do you believe that Trustee Ranovich has violated the Government Conduct Act or any other legal regulations?
Mayor, Trustee Benavides, I think that the Friends of Los Ranchos has put forward in the appeal does believe that.
So 10.16.4 provides for the enforcement of that act. Have you filed a complaint with the Attorney General against Trustee Ranovich?
Mayor, Trustee Benavides, I have not. I don't know what happened before the beginning of June.
Is it your contention that Trustee Ranovich violated the act?
It is Friends of Los Ranchos' contention that Trustee Ranovich violated that act.
So why would the Friends of Los Ranchos hold the Village of Los Ranchos responsible for Trustee Ranovich's violation of the act and not Trustee Ranovich himself?
As you pointed out before, Mayor, Trustee Benavides, as you pointed out before, that's the enforcement provision under the Governmental Conduct Act is the AG's office and the State Ethics Commission. It is not something that the Friends of Los Ranchos can do. The Friends of Los Ranchos can, did, has, does today take the position that that violation of the Government Conduct Act has implications for both the conflict of interest for this quasi-judicial proceeding in terms of the village's bias, and it does void the actions taken by the village in relation to site development plan. It should have done so with the preliminary plot, final plot, but that's not here for us.
So if no complaints are to be filed against trustee Radnovich, do you believe that will undermine the ability of the Friends of Los Ranchos to prevail in district court?
No.
Conversely, do you think that the Village of Los Ranchos will use the absence of a complaint against trustee Radnovich in their defense?
I certainly would.
You would?
I expect your attorneys will. I think that's what they've done.
It just seems odd that you're giving somebody, one side a free pass and not the other. So.
We're not giving anybody a free pass. I'm not here tonight. You'll see in our presentation, we're not focused on that. That's not an issue. And as I said, I think if I were in the village's position, I'd use that in my favor. And if I'm in the Friends' position, I'm using that in my favor.
Well, I think that says a lot with that final comment. That's all I have for him.
Okay, trustee Pacheco,
I have no questions.
trustee Lewis.
I have no questions at this time.
Okay, it is now time for the Friends of Los Ranchos to present their case. Mr. Beck, please approach the podium, state your name and address for the record. You have 45 minutes for opening and presentation of witnesses. So, Mr. Mel Eves, you're going to take the spot.
Yes, sir, Mr. Mayor.
You're welcome.
I would like to offer, before I begin, I would like to offer into the record a couple of exhibits.
If you have anything, please present it to the clerk, and then she can make it available to us.
Okay.
Well, we're not taking any additional documents. I'm sorry.
These are not additional documents.
Well, are they or aren't they?
No, I've got the list.
Oh, they're the same document? We have it then. We already have it.
Okay, I will say this then, that I would move to admit into the record all the documents that are in the statement of the record
They're
that is
all
on
here.
file, here.
Okay, let me ask Kathleen, and maybe this is a question for Nan Winter. As far as I know, everything that was presented by the Friends of Los Ranchos very recently is in these books. Am I correct or not?
Mayor and trustees, everything that's on that list is part of the record, so there's no need to move any of these exhibits into the record.
And we've already decided we're not going to accept anything additional anyway.
That's correct.
So the answer is no, Mr. Eves. We can't accept any more because it's already here. We already have it.
Well, that's what I'm saying. I want to be sure that all of those documents are officially exhibits in this proceeding.
You can be assured.
That's all I'm saying.
Okay, there we
Okay.
go.
Now we understand each other. And for purposes of the record, we have marked those documents with exhibit numbers. And I have here a list of those exhibits. And I don't really need to move that. I think it'll help me and anyone else who wants to refer to them during their argument to identify what they're referring to. So I would offer this exhibit list at the conclusion of my comments.
Well, let me ask this question, and this may be for the attorney. I believe I'm on. When he calls his witnesses, he can do what Mr. Campbell did. He can provide them with a piece of paper and ask the questions. Am I correct or not?
Mr. Mayor, yes, you're correct.
So you can do that.
But what I'm trying to say is that if a number is assigned to it, then rather than having to say the whole name of the exhibit, I can say I'm going to hand you exhibit number so-and-so, and we'll know what we're talking about.
Well, for the purposes of the record, I would suggest that you do what Mr. Campbell has done and say whatever the section is or whatever it is, because you do have 45 minutes. That's a lot of time. If you don't mind doing that, it makes it a whole lot easier for all of us. We have it all anyway.
I'm not going to waste any more time with this. I think it's counterproductive. So I thought it's usually a pretty easy thing to do, and there's usually no controversy about it. So, okay, I want to start.
Before you proceed, can you introduce yourself the way we
Yes,
asked, your name, address? Okay.
I was just getting ready to do that.
Thank you.
My name is John Mel Eves,
Why are we resetting the time? He was given 45 minutes at the very beginning.
Oh, come on, Mr. Mayor.
Go right ahead.
I was trying to be sure what we had in the record on exhibits. You've given Mr. Campbell a lot of extra time. I'd like to have my.
You now
full
have
time.
45 minutes.
Thank you very
Right
much.
ahead.
That's, I appreciate that very much. My name is John Mel Eves, 721 Chavis Road Northwest, here in Los Ranchos. And I'm also an attorney for Friends of Los Ranchos. Mr. Campbell spent a lot of time talking about what this case was not about. I'm going to talk about what this case is about. And what this case is about is that the village of Los Ranchos, together with Palindrome, you've violated I did it by count, 21 ordinances and statutes. What?
What do you mean it's difficult to hear? Conversation. Let's please be polite. No extraneous conversation. Go ahead, Mr. Eves. We need to hear him.
Was I not speaking loud enough?
You're fine.
Oh, okay, all right. And I will get into the details of those later, but that's what this case is about. This is the largest subdivision construction project in the history of Los Ranchos, according to my knowledge. I've lived out here since 1955. And I will bet you that it is the very first project that has allowed construction to commence before site development plans were approved. And I haven't heard anybody disagree with that. If I'm wrong, please tell me. It's highly irregular. And Mr. Campbell was attempting to say a while ago that, well, that approval by Maida Rubin of that site development plan wasn't final. Well, it was final as far as she was concerned, because she was following the procedure outlined in Tiffany Justice's April 21, 2021 letter, in which she said explicitly that 3.3 was being interpreted as allowing the administrator and the director to give final approval without the involvement of the Planning and Zoning Commission or this board. And that's exactly what Maida Rubin was doing. And it says right on the project, on the approval that she did, that it was director approval of it. If we had not appealed it, it would have been final. And even when we did appeal it, it was treated as final by the village because you allowed construction to commence before it was properly approved as required by the ordinance. That's what this case is about. Mr. Campbell seems to think that that site development plan is here, and because it's here in front of you today, you've complied with the ordinance. Well, you haven't. You haven't, because you've allowed construction to continue. It was commenced actually before Maida Rubin made her decision on the site development plan. And then when we appealed it, even though state statute says the proceedings will be stayed, and even though in the past Tiffany Justice has interpreted that meaning John Calvin couldn't build his parking lot, the village changed its position this time and has allowed this project to go forward completely. Not only is that a huge problem that's before you tonight, and it's a mess, frankly. because you've never had that happen before. And Trustee Benavidez' questions are very good questions because you don't know what you're going to do about it. You really don't. If you deny this appeal, what are you going to do about the construction? If you approve the appeal, so what? The construction's been going on anyway. They don't need your approval. You're not the governing body anymore, according to the planning and zoning director and according to the village administrator. Your authority was passed to them under 3.3, which doesn't say that, but it was interpreted by Tiffany Justice in letters dated April 21, 2021, May 24, 2022, and July 29, 2022. It was interpreted in all three of those letters as that you did not have to submit this major subdivision project. You did not have to submit the site development plan and the plats to the board for final approval. That's just wrong, because 3.3 of the development agreement does not say that. I haven't even heard Mr. Campbell say that. They try to justify it by saying, well, look, this is a Metropolitan Redevelopment Act project, so it's different. It's not different, because the Metropolitan Redevelopment Act, and we've cited this in our briefs, but it has a specific provision that it does not void or repeal any local ordinances. And if you read that act carefully, it says those ordinances apply. There is no basis, no legal basis, and you didn't hear Mr. Campbell stand up here tonight and try to give you a legal argument as to why and how the village could let this project go under construction before final approval of any site development plan. And the other problem that is even more serious than that is the final plat approval. The appeal in front of the Planning and Zoning Commission laid out for them exactly what the law was on getting final plat approval. And they understood it. There's three ladies on that commission who have really been criticized very brutally by members of the administration and by Mr. Campbell, who understood what was going on. Because I argued to them, I said, each of you took an oath of office to follow and comply with all state statutes, the state constitution, and these ordinances, and you're supposed to do it faithfully and impartially. That hasn't been done here. What happened on the plats, they were approved in August, the plat, I should say, for the whole subdivision, was approved on August 2022. And there was not one notice that went out about that. There was no open meeting to review it and to consider it. It was approved administratively behind closed doors by two unelected village salaried representatives, Ann Simon and Tiffany Justice.
Tiffany wasn't here then.
Oh, I thought she was still here in August.
No.
Okay, well, she was here right up to, when did she leave, Mr. Mayor?
I think it was July 29th, but I'm not exactly sure.
So she must have written the July 29th letter on her way out, I guess. But I apologize. I didn't realize, I thought she was still here, but her letter of the 29th accurately reflects how the administrative approval was given. And the only kind of approval the plat has is an administrative approval by the director and the administrator and a signature by the mayor. It has not, the law, the ordinances are so clear, and you haven't heard anybody tell you otherwise. You can't do a major subdivision plat approval without the Board of Trustees considering it and approving it. Now somebody tell me how you can justify that. And you were elected by the people in this room to protect them, to protect this community. And it's your job not to let that happen. I would love to know how much information you had about the plat approval. It wasn't done in a meeting. I don't know if you even knew it had been done. And I have a strong suspicion, which is neither here nor there, I guess, but I have a strong suspicion this board has not been kept informed about those kinds of approvals here. And this is just, I mean, I just can't think of words to describe how ridiculous it is that this huge, well, I guess about a $260 million project is underway with a plat approval that is illegal. And it doesn't even have a site development plan because the Planning and Zoning Commission understood this illegality and they said no. Vacate the proceeding where she signed that. And they're still doing construction. You haven't stopped them. What is this Board of Trustees supposed to do? Are you a spectator or are you a participant? I mean, we really want to know that.
Let's be respectful, please.
Yeah, we need to not do that. So and you know, I can sit here and I can talk about the language in 9.2.14, the VC zone, and that's what's used by Mr. Campbell to try to justify what they're saying. You'll notice tonight, he didn't make a legal argument. His argument was totally off base, had nothing to do with the decision that was made by the Planning and Zoning Commission. They made a decision based on the law, based on your ordinances. He isn't talking about that. He doesn't want to talk about that because he can't win that argument, and he's smart enough to know that. I don't see, you cannot approve this appeal and honor, and at the same time say that you've honored your oath of office. Because approving this appeal will be a violation of your oath of office. There's no question about it. There's no basis for it. And what happens if you don't approve it? That's a good question. The village has allowed this construction to get started and go on, and you got a hell of a problem on your hands. Are you going to get sued by Palindrome? I don't think so. I mean, I have a lot of criticism for the way that development agreement is drafted. But one thing I do like about that development agreement is the indemnification clause. It's a good indemnification clause. And as I understand it, Mr. Radnovich was working was an agent for Palindrome when he signed the applications as their agent for the site development plans. And the development agreement, so they knew what he was doing. He was urged, I assume he was asked to do that by Palindrome. But the development agreement also has a clause 15.1 that says Palindrome agrees to comply with all applicable laws, all of them. That means these ordinances. It's right in the agreement. That's another part of that agreement I like. City of Albuquerque did a good job of drafting that part of the agreement. They have violated the agreement. They have violated the agreement. And it's going to be difficult with that indemnification clause and their violation of the agreement and their commencement of construction without even have a site development plan approved. It could be pretty hard for them to win a lawsuit under these circumstances. I think they've taken the risk. And I'm going to have to stop now because I want to leave some time. Where am I on time officially?
You got 31 minutes left.
Yeah, but I've got a partner here who 30 more minutes left. Okay. I'm going to close by saying this because I think this is very, very important. When I went through the ordinance getting ready for the hearing, I counted 21 ordinances and statutes that have been violated by the conduct that I just described. And I hate to do this because it's sort of, I'm going to list them. Of the Village Code 2.4.2, 2.4.3, 2.4.6, those are the ordinances that deal with enacting and amending ordinances. And the only way that the village could have tried to delegate authority to Maida Rubin and Ann Simon as director and administrator and to give approval would be to amend the existing ordinances. There were no amendments of ordinances to authorize, to take the power away from you and give it to them. Nothing. And there couldn't be in the way of an ordinance because there's a state statute that says you can't do that. In addition, as far as violating ordinances, 9.1.1, 9.1.2b, 9.1.5 S, 9.1.7c, 9.1.8, 9.1.8 A8. Those deal with plats. Several of them do. And they say you cannot approve a major subdivision plat without a hearing of the Board of Trustees with notice, open meeting, in which there's a majority vote. Also violated is 9.1.13, and that's the one I want to talk about right now. 9.1.13 is entitled construction violation. And it says that construction violations are strictly prohibited, strictly prohibited. And what we have here is a construction violation because there is no site development plan approved. And the plat that has been approved was approved illegally, not by this board, not by the Planning and Zoning Commission, but it was done administratively without any authority to do that. And the 9.1.3, I want to read that because it's very important. Construction which violates any provision of this article is strictly prohibited, and no building permit shall be authorized except in those cases where modifications or exceptions have been granted through the variance procedure by the commission prior to the start of construction. Violations without authorization by the commission shall be cause for legal action by the village to have the construction violation stopped, corrected, and or removed, and a penalty assessed. That's part of the law that Palindrome agreed to be bound by when they signed the development agreement with the village. They're wide open on that. And this is your power, part of your power, to avoid a lawsuit from them is because you have the power to go to court. Now, the village may have some problems of its own because your hands are not particularly clean. You have allowed these violations, and this Board of Trustees particularly has not lifted a finger to do anything about it. And if you had knowledge of what was going on and did nothing about it, if I were you, I would be concerned about it. because you've got a lot of people here in this room who will never forget that. Never forget it. And I don't know that you would be held liable in a court, but you'll sure be held liable in the court of public opinion. And I'm going to finish by saying, I can't imagine how you could approve this appeal in light of the argument you heard from them. They didn't defend any of these points. They really didn't. They didn't answer these legal issues. And you have sworn to follow the law. And that's what we're all asking you to do. Please follow the law. Deny this appeal. And it's going to be it's going to cause a problem. But it's a problem you helped create because you didn't tend the store the way you should have. And I'm not trying to be rude or anything like that, but we got a problem. And I think if you stop it right now, you know, back in February, when we first made an objection to the site development plan, because that was the first public notice, that's the first public notice of a zoning application in this case. David Campbell, who I love, loves to say that there's been all sorts of notices. But he's playing word games with you. We're talking about public notices as required by law. This notice that was given of the site development plan was the first notice of the type required when you're handling zoning applications. And, you know, it's hard to defend anything that happened before that. And I'll shut up so you can have your part in that. Thank you very much.
Mr. Beck, state your name and address again, please, for the record.
Matt Beck, 21st Plaza, Suite 725 in Albuquerque, 87102. You can tell I've been working a lot with Mel because I gave him a 1-minute warning 7 minutes ago, thinking that he would finish by 25, but we weren't quite there. I'm more of a visual learner, so you've got this PowerPoint in front of you. What Mel just talked about is spot on, and I'm going to exhibit to you why that is. In slide 2, the village is not a home rule municipality. It can only exercise the police power as given to it by state statute. And as Mel just pointed out, you have violated, and he read from slide 10 of the village ordinances, but you have violated 9 state laws in building this project under Article 3.3. Now let me go back, and this is not in your slides, so I see only Trustee Benavides is following along. Well, let me go back and point out one thing that Mr. Campbell said, which was that we were gonna get up here and tell you that we should have made this decision to appeal the purchase site development agreement, that's Exhibit 14, 3 years ago. That's not true. No one knew at that point that the village would interpret that provision to violate all these ordinances and state laws. It says, and this is slide 6, and this one's important for you. It says, slide 6 puts this agreement up against the agreement for the El Vado development with Palindrome. And you can see that these are almost word for word. But there are differences here, and they are important differences. It says that, that Palindrome would submit all the plans to the Planning and Zoning Director and Administrator for approval in accordance with Section 9.2.14. Nowhere does it say that those two people would approve it. Nowhere did it say that they would approve it without public notice beforehand and public comment at an open hearing where they consider that, both of which are required by the Open Meetings Act, both of which are required by 9.1.8. What is not required by 9.2.14 is anything. That is one of the worst provisions I have ever seen. No disrespect to you, no disrespect to Mr. Craig, who approved that without any comment or even talking about it at that meeting. It is awful. It gives no guidance. You can't even read it to exempt this Village Center project from it. But that is one fair reading. But 3 years ago, no one could have seen, and no one did see, that this provision was going to be interpreted that way, because when this was presented in October of 2020, Village Council told you that this was based on the Elvado Agreement, did not mention Section 3.3 at all, did not mention Section 3.2 at all. We have gone back and compared what is Exhibit 3 in your binders, which is the Elvado Agreement, with Exhibit 14 in your binders, which is this agreement. And those are important differences in slide 6. Because for plots in the Elvado Agreement, it says, quote, approval from the appropriate governmental authorities of a plot. Because the city of Albuquerque drafting that agreement and Palindrome looking in that agreement knows that's what's required by state statutes, knows that that's what's required in particular by Section 327 and 328. It requires the Board of Trustees to approve major subdivision plots. It provides that you can do a summary procedure. So if you don't want to do that, the legislature thought about that, and it gave municipalities like the Village an opportunity. But it did so only for 2 plots. For 2, not 14, like was done here. And when the legislature says you can have a summary process, if you do it correctly, you can't do otherwise. That's the only way you can do it. And your ordinances include that same process, that same summary process that are in state statutes or in your ordinances. But it doesn't say the village administrator and planning zoning director can do that. Then you look at 3.3 and compare it with the exact same language in the Elvado Agreement. The Elvado Agreement says that developers shall submit such plans and specifications to the MRA manager for approval prior to submittal to the city's planning boards, commissions, and staff. You submit it to the MRA director before it goes in front of the boards that always approve major subdivisions, because again, that's what's required by state law. The city of Albuquerque knew this. Palindrome apparently knew this, or at least agreed to it. 3.3 doesn't say that. It doesn't say anything about the Planning and Zoning Commission or the Board of Trustees. Notably, it doesn't say it wouldn't go in front of you. That came on April 21st, 2021. On April 21st, 2021, Exhibit 15 in front of you was provided to Palindrome and the Village. And that set out the requirements that made plain that the execution of this project would violate 21 ordinances and state statutes and the Open Meetings Act. And as you'll see in this PowerPoint, the Court of Appeals has said that either one of those invalidates everything that has been done to date. And so Trustee Benavides asked the question, well, what do we go back, what do we do if it's not invalid? Why don't we just defer this and wait until a judge decides? This is your opportunity to follow the law now and not require that judge to decide, because that judge will decide the way it has to based on the Weinstein case that decided this exact issue. And it will decide, A, there is no state law or ordinance which allows the village to delegate the Board of Trustees' responsibility to approve major subdivisions to the village administrator and planning and zoning director. And just like the Court of Appeals had when the State Investment Council delegated to a litigation committee, it held that delegation and the litigations committee approval of settlement agreements was void. Because as a municipality, as a state agency, you can only do what the government allows you to do in the state laws. It also held that because that litigation committee approved the settlement agreements without public notice and did so not at a public hearing, that it had the power to do that. By violating the Open Meetings Act, everything it did was invalid. And so I answered Trustee Benavides. I said, you know what? We're not focused on Trustee Radnovich, and it is true. because, as Mel pointed out, your violations of law will have a judge, if you do not tonight, invalidate everything that has been done in this project. The violations of the Open Meetings Act, by A, your delegation of that authority unlawfully, and B, by the village administrator and planning and zoning director not providing public notice, not issuing their approvals after a public hearing, invalidates everything that's been done on this project. And so this is your opportunity tonight to not defer, to not wait for a judge to do that, and to not incur any more costs, fees, time, and resources, but to recognize that and recognize that tonight is your opportunity to correct those rights, correct those wrong, make right what you have to do. I want to talk to you about the Open Meetings Act. This is the second reason that all of the approvals are invalid. The Open Meetings Act requires that any public business of the village be done at an open meeting after a properly noticed public hearing. I don't know, but I would assume each of you has had training on the Open Meetings Act. That is something that you all know you are subject to as the Board of Trustees. It's why in every one of your agendas at the end, you have that provision that says this was done public notice. More pointedly here tonight, it's why we weren't here a month ago, because the village didn't provide proper public notice for this public hearing. And it is wild that anyone could think that approval of a major subdivision that is provided for in 3 different articles of the New Mexico statutes annotated and 2 different articles of this village's ordinances could be done without the open meetings applying is wrong. It is very wrong. And I will point out the reasons to you. On page 23, we talked about the provision in the Alvado agreement. This is slide 23, that provides the MRA director would get approvals. The city of Albuquerque has a Metropolitan Redevelopment Agency. Why? Because the Metropolitan Redevelopment Code, which allows the village to have development agreements for Metropolitan Redevelopment Acts, just like the state statutes for major subdivision approval, allows these metropolitan redevelopment projects to be delegated to a committee, but not to the village administrator and not to the planning and zoning director, to the Metropolitan Redevelopment Agency. That's section 360A-15. You'll see it in these slides when you go back and review it. And again, when the legislature provides you a way to do something, as a municipality that can only act how the legislature delegates, that's the only way you can do it. By delegating this to the village administrator, planning and zoning director, it was unlawful. Now, the city of Albuquerque has that Metropolitan Redevelopment Commission called the Albuquerque Development Commission, which I'm sure Palindrome knows well about because they had to go through it for the Alvado project. And I assume, in fact, I know without knowing, for every other project they're developing in Albuquerque. That Metropolitan Redevelopment Agency posts its general meeting information online, gives public notice, including its agenda of what it will decide at its meetings, and makes decisions on these metropolitan redevelopment projects at open meetings after public comment, because that's what the Open Meetings Act requires. And so the Metropolitan Redevelopment Code is not some magical exemption from the Open Meetings Act. It is not. Everything that this body does is subject to the Open Meetings Act. You know that. And the AG's compliance guide, which I brought to show you, but you can find it elsewhere, provides specifically that a board subject to the Open Meetings Act cannot delegate its authority to a body or a committee or a single individual if the actions taken by the Board of Trustees would be subject to the Open Meetings Act. And so there is an argument, and this is slide 26, the Village Council's response to Joe Craig's Open Meetings Act notice. And it says, the OMA does not by its terms apply to the approval of the plat, thanks for that correction, or site development plans by the village administrator and planning and zoning director. Those approvals did not involve conduct of business by a vote and were not made during a meeting of a quorum of members of the Board of Trustees. I have given you at least 5 points why that's totally wrong. The first of which is it did not conduct business by a vote. How else did two people conduct business? I will certainly submit to you that I don't think the village administrator and planning and zoning director did parliamentary procedure like you did today and called the question and took a vote on that. But they both approved it, which is a vote. It's a vote yes, just like you're gonna have to do for this. And so that is wrong. They did take it by a vote. Nothing in the Open Meeting Act says that that vote has to be announced. Well, that's probably not true. It does. It has to be done in an open meeting, but that's a different point. Were not made during a quorum of the members of the Board of Trustees. And for that, it cites this Paragon Foundation Incorporated versus New Mexico Livestock Board. Because that's the only authority provided for that, in slide 30, I have provided you the Weinstein decision, which specifically says why that council's reliance on this decision is completely wrong. It says that in that decision, we did decide that the director of the livestock board's approval of an MOU was not subject to the Open Meetings Act. But it says, quote, we also noted that the executive director's, quote, largely unilateral action was non-binding and meaningless, as he can only act pursuant to those powers delineated in the code, meaning that the approval of the MOU didn't bind the village, didn't mean anything, wasn't worth the paper it was written on. If that were true, in relation to the site development plans and the plats, preliminary and final, we wouldn't be here tonight. I don't think anyone is contending that the actions of the village administrator and planning zoning director do not bind the village. It's the opposite. Mr. Campbell just told you they did. Trustee Benavides was asking, now that we're bound, what happens? This goes on with the Court of Appeals. In Paragon, importantly, we noted that the executive director did not have the authority or approval of the board to enter into the MOU. No one's telling you, and you all know it's not true, that the village administrator and planning zoning director here did not have the approval of the board to approve the preliminary plan, the final plan, and the site development plans. That's specifically outlined in 3.3, specifically outlined in Exhibit 15, that requirements letter, and it's why we're sitting here today, because everyone is contending, and you all will agree, that they had the authority of the board to enter into these, to approve these site development plans. Court of Appeals also distinguishes Paragon decision saying that the MOU was not approved or authorized by a quorum of the board in public or private meetings. Again, that's not true here. As Mr. Campbell pointed out at length, the development agreement was approved by a quorum of the board. You have a vote of the board, as the AG's Compliance Act points out, illegally delegating the authority. That is a violation of the OMA. It invalidates everything that has been done on this Village Center project. And it can be done tonight, or it can be done after lots and lots of litigation. Signs off. These facts clearly distinguish Paragon Foundation from the present matter. Unlike in Paragon Foundation, the New Mexico State Investment Council, like the village, unanimously approved the settlement policy purportedly giving the litigation committee authority to act on its behalf. That's exactly what you did in the development agreement, giving the administrator and the director authority to act on your behalf. It is clear that the NMSIC fully endorsed the actions of the litigation committee and intended it to take action that would be subject to the OMA if acted on by the full NMSIC and invalidated those settlement approvals. Same thing here. It is clear that you delegated to the village administrator and planning and zoning director and intended that they would take action that would be subject to the OMA if you all did it. And the fact you had to cancel the last meeting last month shows that. Slide 33 provides the Metropolitan Redevelopment Code, and what that actually provides, as distinguished from what's in Exhibit 41, which is your attorney's response to Joe Craig's notice letter. And you'll see in the highlighted portion that the Village Council says it gives you authority to vary from its typical approval process. We heard about that typical approval process tonight. It says, including the power, quote, to plan or replan, zone or rezone any part within the jurisdiction. Well, that is partially what it says. But what Village Council omitted from that quotation, the prefatory clause, as I previewed for you 2 weeks ago, is the most important part of that. And that's found in that first top right part of I, which is that in accordance with applicable law or ordinances, to plan or replan, zone or rezone. That's what was done in the Elvado agreement. It went through the MRA because they had an MRA before it went through the commissions that approve these all the time, because that's what the law requires. I talked about Section 15, which provides what you all wanted to do here and may still want to do, that you may, as the local government, directly exercise your powers here, or may, by ordinance, elect to delegate the exercise of such powers to the Metropolitan Redevelopment Agency, created pursuant to the Metropolitan Redevelopment Law. If you can do it for the agency, you cannot do it for anyone else. You can't do it for the administrator, you can't do it for the director, you can only delegate to the agency, which is still subject to the OMA. The last part of that highlights Section 368-47E and F, which says that this law does not trump other laws unless they are inconsistent with it. It does say if there are laws inconsistent with this, the Metropolitan Redevelopment Code trumps them. But there is nothing inconsistent with having an agency decide these matters that does so, as Albuquerque does, with public notice and public comment at an open hearing. Not only is it inconsistent, that's what the law requires. So the village can do some of what it's trying to do here. It can delegate what happens to some extent under this Metropolitan Redevelopment Project. It can. The law provides for that. But it can only do so to the Metropolitan Redevelopment Agency. And there is not one for the village. You all may decide that you want to have one. That's appropriate. But the law requires you pass an ordinance before you can do that. It also requires that that be 5 commissioners. It gives specific terms for the commissioners, when their terms start, when they don't. You all are intimately familiar with that. You can have development agreements. Metropolitan Redevelopment Code provides you the power to do that. You may plan and replan. The Metropolitan Code provides you the power to do that. But you have to do all of that in conformity with your now existing ordinances and with state law. And Article 3.3 does not do that. The changes that were made from the Elvado agreement to this agreement make it illegal and void, whether tonight or in the future, everything that has been done with this project. And you will have to go back and redo all of those steps again in accordance with your ordinances, which means that they may submit their preliminary plot, their final plot, and their site development plans to the planning and zoning director and village administrator. But after they do that, each one of those, preliminary, site development plans, and I guess only the final if they have comments, have to go before you at a properly noticed meeting where you take public comment like you're about to take from all these folks here. And that can either happen soon without incurring more costs and fees. if you decide tonight to deny Palindrome's appeal, or it can happen in years when construction has taken place. And if after those years, there's a different board of trustees who maybe doesn't agree with the plats or doesn't agree with the site development plans, the village is in even more of a pickle than it is tonight. And so I'll leave you as Mel started, that you all took the oath of your office, that you will support the Constitution of the United States, Constitution and the laws of this state, and that you will faithfully and impartially discharge the duties of the office to the best of your ability. And that's why, in answer to your question, Trustee Benavides, you all have to act tonight and deny this appeal and get started with doing this project in conformance with laws and ordinances.
Thank you very much, sir. It is now time for the applicant to ask questions of Mr. Beck or Mr. Eves. Mr. Campbell, do you have questions? If so, you have 15 minutes. Again, this is not the time to argue, but instead cross-examine.
Mr. Mayor, trustees, I didn't see any witnesses from Friends of Los Ranchos, and I'm not going to cross-examine the lawyers. So there is no cross-examination because there was no factual evidence to be cross-examined here. Thank you very much.
You're welcome. It is now time for the trustees to ask Friends of Los Ranchos questions. We will have each trustee ask their questions before moving on to the next trustee. Let's start with Trustee Pacheco.
I have none at this moment.
Trustee Lewis.
I have none at this time.
Trustee Benavides.
I have questions for Mel Eves, since he was a speaker.
Yes, sir.
Do you believe that Trustee Radnovich has violated the Governmental Conduct Act or other legal regulations?
Yes, I do.
So 10.16.4 provides for the enforcement of that act. Have you filed a complaint with the Attorney General against Trustee Radnovich?
No. Our reason we haven't, our interest is this project. Our interest is this village. We're not in the business of pursuing somebody who has that type of conflict of interest. The people out here don't have the money, the legal money, to spend on that kind of project.
So why would
the village is responsible for it.
So why would the Friends of Los Ranchos hold the Village of Los Ranchos responsible for Trustee Radnovich's violation of the act and not Trustee Radnovich?
Because, well, there's different ways to hold people responsible. I'm not saying we're going to get money damages or something like that, but the mayor and Simon, Tiffany, Justice, all knew that he was a trustee when he signed that application, 3 applications for site development plan. They should have never accepted it because the village is very careful about informing all of us and the trustees and the employees about conflicts of interest. It's right in your ordinances. This is something you're all charged with knowledge of. They are charged with knowledge of it, and certainly your council's charged with knowledge of it. And if all those people who took oaths of office allow that, that's terrible. That's terrible. And it makes what he did invalid. And that's what we're interested in. We don't think that Palindrome should have the right to get those applications approved because they basically gave something of benefit to a sitting trustee. And that, you don't have to be, that's not rocket science. That's wrong. And it shouldn't have happened. We're not going to sue you or the village to get money damages, but we'll certainly try to undo the damage he did with his conflict of interest.
But don't you believe that if no complaints are filed against Trustee Radnovich, that will undermine your ability for the Friends of Los Ranchos to prevail in district court?
Not a bit, not a bit. It's going to make the village look bad. Your integrity is at stake for allowing it to happen, but it's not going to weaken our case.
Even though you believe he violated the governmental conduct?
You think a court would punish us for his conflict of interest? No.
No,
not
but
gonna
you're
happen.
trying to win a legal argument in a district court. Thank you.
No, I don't think a district court is going to judge us one way or the other because we didn't take action against him. Our bone to pick is with the village.
It's kind of hard to separate the two, though, isn't it?
Well, I don't think it is, but, you know, the truth of the matter is that he's not a bad person. You know, I don't dislike him. He did something that wasn't very smart, basically, and he shouldn't have done it. But that's not what our lawsuit is about, and it's not what our complaint with the village is about. The village officers allowed him to do that, and they knew who he was. They shouldn't have done that.
So he didn't violate his oath of office then?
Oh, I think he did.
Okay.
I think he did. He did not comply with the laws of the state of New Mexico and the ordinances of the village. I think it was a breach of his oath of office.
Thank you, Mel.
Any further questions, Trustee Benavides?
That's all I have.
Okay, it is now time for public comment from only those individuals that spoke at the May 9th, 2023 Planning and Zoning Commission meeting. I will call up each individually. Please state your name and address. You will have 2 minutes, and you must adhere to the 2 minutes. Tom Donnellan, please come forward.
Good evening, Mayor Lopez, Board of Trustees. My name is Tom Donnellan, and I reside at Los Ranchos. I'm a resident of Los Ranchos de Albuquerque at 6668 Edgewood Drive Northwest. I speak against the approval of SDP 2301, 2302, and 2303. What exists at 4th and Osuna was designed without P&Z, Board of Trustees, or resident input as prescribed by village ordinances. The development agreement was presented to the Board of Trustees without noting the change in the approval process, sidelining the Board of Trustees and the public without notice to the Board of Trustees, contrary to every other development in this village. The design is contrary to the Metropolitan Redevelopment Plan and the RFP that the development is based on that plan. The staff approval of the site development plan were issued in disregard to village ordinances. The development has been constructed without site plans being approved. Construction continued after notice of the appeal was filed and affirmed by the P&Z Commission. These design plans should only be on paper, not significantly constructed through the illegal actions of Palindrome, village mayor, and staff. This Palindrome Village Center site plans are not in keeping with the village master plan. This huge urban residential development flies in the face of the very origins of this village and every master plan since then that defined the village as a rural, semi-rural village in contrast to the urban city of Albuquerque on our borders.
Your time is up, sir. Thank you.
Thank you.
Gordine McKenzie, please come forward. State your name and address for the record. You have 2 minutes.
I agree with the previous speaker and won't repeat what he said. Gordine McKenzie, 7315 Guadalupe Trail, Northwest. What I want to focus on is the lack of concern for the residents, for the neighbors that are backed up to Palindrome. Recently, I heard that the apartments look directly into someone's kitchen window and into someone's bathroom. This is not okay. There is no sound barrier. There is no privacy wall. Trees are not buffers against sound. Trees are not buffers against light pollution. I've talked before, if we really cared about affordable housing, it would have been done in a much better way that considered the residents of affordable housing as well as the village residents. There's no parking for all. I don't know how that happened, that there's not enough parking for the residents that are going to live in those apartments. How are they going to get things back and forth? How are they going to move in? How are they going to get groceries and other things? As you know, in the news lately, there have been stories about other properties that are owned by Palindrome and its affiliated corporations, where residents have leaky roofs, no air conditioning, leaking water heaters, rent prices that keep jumping, and short-term leases, and people end up on the streets. Furthermore, traffic is terrible. I have talked to the sheriff's office and learned that—
The speaker's time has expired.
Okay, in a 1 month period, there were 4 crashes on 4th and Asuna.
Thank you very much, Gordine.
There's a minute, second left, Daniel, legally.
Sorry. Nancy Mangiaroni, please come forward. We'll be a little more diligent when we watch the clock, okay?
Thank you.
I appreciate that. And I wanted to comment about something one of the witnesses said.
Go ahead.
About,
State your name and address for the record, please.
well, I don't want to eat into my time because 2 minutes is really short. I'm used to 3. Nancy Mangiaroni, 7315 Guadalupe Trail. I attended the first open meeting presenting this development, and I spoke with the 2 architects who were there, and they both told me there was nothing they could do to change the way that this project was going. They couldn't do anything with these first 3 huge developments. We all know what rush hour at 4th and Osuna and 2nd and Osuna is like. Slow, backed up, miserable. We all know what traffic on Chavez is like. Too heavy, too fast, too difficult for local residents to enter, too dangerous for pedestrians, equestrians, and bicyclists. The Palindrome development is only going to make all of this worse. But because of shortcuts taken in this project's approvals, we had no chance to study the likely traffic effects. We had no chance to require reasonable mitigation measures in the project design. Instead, in defiance of our village ordinances, we were presented with a finished design that could not be changed. The Palindrome project is a grotesque perversion of what the village wanted in its place. We wanted a community center and maybe some senior housing, not a huge senior unfriendly housing development. We wanted modest buildings that respected views, not a 3-story street crowding, mountain blocking behemoth. This administration, and I'm not talking about the trustees, has not been transparent. Like with the beef jerky deal, it was a year in the making, but trustees were excluded until their vote was required. You have removed all public oversight from this process. You gave away our land and our voices in what was to be built. Tonight, I have just one request. Uphold our
The speaker's
village.
time has expired.
Thank you. Uphold our village ordinances. Vote with us. Find the courage, the will, the compelling reason. Vote with the people. You know that we do not approve of the Palindrome site plan, not
The speaker's
any of
time
it.
has expired.
Your time is up.
Vote with us.
We
It
hear
is
you.
the right thing to do.
We hear you, ma'am. Your time is up.
Deny the Palindrome appeal. Thank you.
Patrick Hurley, please come forward. State your name and address for the record.
Nope, I'm waiting.
Thank you. Okay, Hank Kelly, please come forward. State your name and address for the record. You do have 2 minutes.
Hank Kelly, 6900 Rio Grande Boulevard, Northwest. Mayor, trustees. I am very concerned about the quality of your representation. Your village council has appeared before the Planning and Zoning Commission as an advocate for the administration, did not represent the Planning and Zoning Commission, did not assist it with findings of fact. And only for the first time is there independent counsel sitting at this table allegedly to represent you. I really think you need to get good advice of counsel concerning what's going on here today. I think Mr. Beck very, very eloquently outlined to you the serious problems that this project presents to you. And you have the ethical and constitutional obligations to get it right. Please recognize that your council has a very serious conflict of interest, and you better get independent counsel. Thank you.
Thank you. Let's be civil, please. R. Foster Seaton, is that correct? Please come forward. State your name and address. You have 2 minutes.
Ronald, excuse me, Ronald Foster Seaton, more generally known as Terry Seaton, 336 Naravisa Court Northwest. Increased population density requires disproportionately increased expenditure for public services and therefore represents an increase in per capita revenue required. Allow me to state some basic examples. First, if you build taller buildings, I don't know how it applies to 3, 5, 20 stories, you require not merely additional fire equipment in proportion to the increased population, but also more advanced equipment and supply. For example, possibly taller ladders and increased hydrant pressure, and disproportionately increased training of personnel. Second, if you proverbially pack people together like sardines, they have disproportionately more interactions than rural or suburban people, and consequently disproportionately more adverse interactions, which then requires not merely proportionately increased policing, but disproportionately more policing. It may seem unrelated that this board recently passed an ordinance allowing the village to increase our property taxes without limit as to percentage or amount for the sake of conducting a proposed project, but such an increase makes my previous testimony look downright prophetic. I recognize there's a supposed disconnect between funds required for the project at 4th and Osuna and funds required for the purchase of Anderson property. Nevertheless, there is this point reconnecting the two, that if you had recovered from the disposal of the property at 4th and Osuna the funds expended for the acquisition of that property, you would now in all likelihood not require new funds for the new purchase. I propose to you that you or your successor board amend the recent ordinance to place the financial burden squarely on the shiny new economic village.
The speaker's time has expired.
Your time is up, sir. Thank you. Lauren Marble, please come forward. State your name and address. You have 2 minutes.
Lauren Marble, 338 Naravisa Court Northwest, and I'm so happy to be at this first hearing on this project. There's been a huge omission. We had lots of information tonight. No one has talked about affordable housing. These 3 site development plans were for affordable housing. No one uses the word. I in my opposition in February, saw a big problem. How can you do affordable housing if you don't have an affordable housing ordinance and plan? State law is so clear. In section 627.7, it says, any municipality that wants to have an affordable housing project starts with a foundation with an affordable housing ordinance and plan, which solves the problems of where you're gonna put it, your infrastructure, are you gonna have enough access, how is the density? You get these things laid out, and then you apply for your funds. This was never done. We don't have an ordinance. We don't have a plan approved by the Mortgage Finance Authority, which is required by this state law. And as a result, we've got a huge unplanned mess that the county came in and helped finance. So I think we've got serious problems with the state, with the Mortgage Finance Authority. They've been very quiet about this whole thing that they kind of allowed to happen. So I'm looking forward to hearing more about it. We've heard nothing from David Campbell. We've heard nothing from the village attorneys. They've been totally silent on this because there's no defense to it. They hope it'll go away. They don't use the word affordable. So that's my big concern, and I'm hoping someone will at least think about this and factor it in.
Thank you.
Thank you.
Jennifer Kiefer, please come forward. State your name and address. You have 2 minutes.
Perfect segue, Lauren. I'm going to talk about affordable housing. Jennifer Kiefer, 722 Mullen Road. Mayor and Board of Trustees. I'm taking a different approach because you need to be aware of what you are considering tonight. I'm coming to you tonight pleading with you to deny Pelodrome's appeal to the decision of planning and zoning. We all agree that affordable housing is necessary in New Mexico, but the way it came about was deplorable. There was no public input. The Planning and Zoning Committee was not involved until after construction commenced, and you were circumvented from the process. You were elected to protect the village and its residents. Village land should not have been sold for $5 to a private multi-million-dollar developer. When the administration creates an ordinance and are being guided by its legal counsel to disregard the public process, it is very concerning and needs to be stopped. This project was built under the pretense of affordable housing, just like all of Pelodrome's other developments. Sawmills Tenant Union, in partnership with the People's Housing Project, have had to unionize against Pacificor, the tenant management company owned by Chad, to fight for tenant rights. Many of their tenants are facing eviction because they cannot afford rent. They're forced into short-term leases, have no heating, air conditioning, and are dealing with overflowing trash because it's not being picked up frequently. They are victims of Pelodrome's bait and switch and their unfounded promises. The village is already facing a major problem in one of their design flaws. 200+ apartments and only 100 spaces. Would the community grassroots organization Fighting Pelodrome please stand up? These people are opponents and should not be victimized by the village. It's already beginning that way. Are we going to allow this to continue in our community? Is this what village stands for? And are you going to allow those who need affordable housing to
The speaker's time has expired.
Your time is up.
victimized under your watch?
Thank you.
Deny the appeal.
Thank you. Okay. Robert Chavez, please come forward. You have 2 minutes. State your name and address. After this, we're going to take a 5-minute break. You're the last speaker. No, go right ahead, sir. No, I need the restroom.
Robert Chavez, 324 Enchanted Valley Place, Northwest, Village of Los Ranchos de Albuquerque. I'm here tonight representing 668 signatories of a petition that should be in your packet that was presented to the Planning and Zoning Commission in the appeal hearing of May 9th. And also the 28 volunteers of Keep Los Ranchos Rural that walked the neighborhoods getting those 668 signatures on this petition. And they covered a wide range of the neighborhoods in the village. You will find signers from Dietz Farms, Tinnen Farms, Caballero North, South, Chavez Road, Guadalupe, Mullen, El Paraiso, Willow, Edgewood, Elwood, Naravisa, Schulte, Enchanted Valley, Tyler, Green Valley, Roll, and all the neighborhoods down the North 4th Corridor. The petition had two objectives and two statements. One is the support of the FOLR appeals to the P&Z, and in addition, a request that the village officials restore some trust by abandoning the illegal administrative approval process that that SDP 2301, 02, and 03 were approved by, unfortunately, by the administrator and the planning and zoning director. So I just wanted to make note of those residents, 668 constituents of yours and their concerns. Thank you.
Okay, we're taking a 5-minute recess. We'll reconvene at 20 minutes till 8. Time is 7:40. So, 7:45. 7:45, I'm sorry.
That's good.
It's going live streaming out right now.
Okay, good. You gonna show me a picture?
The grapes are, there's some Concords.
Oh, grapes. Oh, yeah.
And the Malfoy grapes and Muscatel.
Muscatel, people make wine out of that.
Right. And we have the Malfoy that on the blonde grapes that we have are sweet. And we have the Muscatel that are bluish. We have those three grapes.
I should teach you guys how to make wine. I got so many grapes, I don't know what to do with them.
Have you seen my fences? No. Nobody will come here. I've offered them for free. I don't make wine. I got everything to make wine, and I don't know what you do. I don't even use this stuff. I have my own bacon.
Bake juice and juice.
We're going to reconvene in 1 minute.
Kids don't like grape juice. It's beyond wine, and the birds and the wasps love it. So, but that's, I found out what our grapes are.
Please take your seats. I am reconvening the meeting. Thank you. The time is 7:48. At this time, the appellant/applicant has 10 minutes for their rebuttal. Mr. Campbell, please approach the podium.
Mr. Mayor, trustees, today's the day. This is the public hearing. The site development plans are right in front of you. They are exhibits 34, 35, and 36. We provided factual testimony about the site development plans from Ms. Greenhood and Mr. Means, and they were cross-examined by opposing counsel. We provided factual testimony on the history of this Village Center project from the trustee at the time, and the planning and zoning director, who testified that there were dozens of open meetings and the vision of the prior trustees, mayors, and residents as to this very project. The site development plans are here before you to approve by approving this appeal. I've been a lawyer for 37 years. In fact, October 6, 1986, I have a document that I was sworn into the New Mexico State Bar, and the signature of the person moving my admission was John Mel Eves. Thank you, Mel. It's been a good career, and I appreciate it. That's why we have a mutual love affair with each other and our families. And the nature of our business is that we do this. We have to help our clients achieve what it is that their goals are. And so in that time, since Mel signed my admission ticket into the bar, I've been doing this kind of cases, municipal law, zoning, and planning, and I want to let you in on a little lawyer secret. When a lawyer realizes that they have no real case on the merits, that is, on the site development plans, what do? They do what Mr. Beck has done here, and they find other problems, not on the merits, but on something else, making unfounded allegations against public employees, claiming bad behavior and skullduggery and ethical violations and illegal procedure, and somebody signed something that they shouldn't have signed. They call attorneys names. They harangue the Board of Trustees and threaten electoral defeat. They threaten more litigation, which is what Mr. Beck has done today. So what they're doing here when lawyers do this is they're trying to overcome not having a case on the merits about the site development plans, which have been ably presented here. But they also are preparing and creating issues so that when they go to court again, they can tell the judge that the process was wrong, that the judge should throw out the municipality's decision, and none of this is about the actual issue on the merits, but about the other stuff, the chaff, the bright, shiny objects that they have thrown out there. The Friends of Los Ranchos, you may have noticed, didn't put on a witness. They didn't have facts. It was all lawyers and argument and legal issues, you name it. But they went through all of them. There was no testimony about the site development plans whatsoever. In this case, when they realized long ago that they had not a case on the merits, they have already filed 3 lawsuits in district court against the village, making all manner of accusations. In June, the most recent hearing we had in court, they asked Judge Barella Shepard to step in and prohibit this Board of Trustees from making a decision in the case with their writ of mandamus. The court wisely denied this and sent the issue back to you, the elected representatives of the people. So tonight, we're here. Tonight's the night. This is the public hearing. These are the site development plans in your record. And we're asking that you approve those site development plans and approve the appeal that Palindrome has made in this case. I appreciate the time you've given us and the consideration for this case. Thank you very much, Mr. Mayor and trustees.
Thank you, Mr. Campbell. This concludes testimony, all testimony for the appeals. The floor is now closed for comments. Before I ask for a motion, and there will be 3 votes forthcoming, I want to ask each trustee if they have anything they want to say, any question. I'm going to start with Trustee Lewis.
I don't at this time. Thank you.
Trustee Mayor Pro Tem Pacheco.
I just would like to thank everybody for coming out and staying active and continuing to keep eyes on the village. I think that's important. I do what I do because I had an interest in the village and what was happening within the village. I think we all can say that 20 years ago, the village wasn't what it is today. And 20 years from now, it's not going to be what it is today. So we all have to remain, I believe, active within our community, which you all are doing. And I just wanted to say, I read through these 2 binders. I feel like I have every possible bit of information that I need to make the decision. But again, just wanted to thank everybody for all their efforts tonight, for everything that they provided. It is greatly appreciated by me as a trustee, and I'm sure my fellow trustees as well. Thank you.
Trustee Benavides.
I just feel that everything pivots on the development agreement, and which is a legal agreement, and I get it in the court of public opinion. People do not like high-density developments. You won't win in that court, and regardless of how this ends up, there's no exoneration by the people that are against high-density developments. I have other concerns, especially in regards to the first appeal that went before the Planning and Zoning Commission by the Friends of Los Ranchos. You know, I wonder if that was even in their jurisdiction to begin with, because P&Z acts on matters of planning, platting, and zoning. So I'm just concerned that it's hard for me to even make a decision tonight.
Thank you, sir. The floor is now closed for comments. The first motion that I need is to approve or deny the appeal to SDP 23-01.
Your Honor, Mayor, before we get there, I've got one more thing.
You're not allowed to speak anymore, sir.
I just need to make my record clear for the district court as this is going.
Is this permissible, ma'am?
And I get that. I'm still going to make my record because this is going before the district court.
I'm sorry.
You've made clear you're not going to accept more exhibits, and that's fine. So I want this marked as Exhibit A, that you denied this exhibit based on July 12th as Exhibit A.
We have it.
And I just want to say that Exhibit 45 was accepted, as I've written, in favor of palindrome after you all made your decision, different than you made tonight. So I want to make that clear for the record.
Very much,
I have. Thank you.
You're welcome. Okay, I need a motion to approve or deny the appeal to SDP 23-01.
No, I was just going to ask, Mayor, are we going to do these?
One by one.
One by one?
That's correct.
Okay.
I've been here for this whole process, trustee for 9+ years. And I believe strongly in our process of how we do things in this village. I believe strongly in the people before me, previous trustees, mayors, village staff, village council, all the people at the village staff that work so hard, and we all care very much about this village. And I believe in our process and that we followed the process. We did our best. And based on that, I'm gonna make a motion to grant the appeal for SDP 23-01.
I'll second that.
Any discussion from the governing body? I'll go trustee by trustee. Trustee Pacheco.
None.
Trustee Lewis.
None.
Trustee Benavides.
I have none.
Okay, I'm going to call for the question. Call for the roll call vote. Trustee Pacheco.
Yes.
Trustee Lewis.
Yes.
Trustee Benavides.
I abstain.
Abstain. Motion carries 2-0 with one abstention. Now I need a motion to approve or deny the appeal of SDP 23-02.
I'll make the motion to approve the appeal to SDP 23-02.
I need a second.
I second.
Any discussion from the governing body? I'll go trustee by trustee. Trustee Pacheco.
None.
Trustee Lewis.
No.
Trustee Benavides.
None.
Okay. I'm going to call for the question, call for the roll call vote. Trustee Pacheco.
Yes.
Trustee Lewis.
Yes.
Trustee Benavides.
I abstain.
Thank you. I need, the motion carries 2-0 with one abstention. The final, I need a motion to approve or deny the appeal of SDP 23-03.
I make a motion to grant the appeal for SDP 23-03.
I need a second.
I'll second.
Any discussion from the governing body? I'm going to go trustee by trustee. Trustee Pacheco.
None.
Trustee Lewis.
None.
Trustee Benavides.
None.
Okay, I'm going to call for the question. Call for the roll call vote. Trustee Pacheco.
Yes.
Trustee Lewis.
Yes.
Trustee Benavides.
I abstain.
Thank you. The motion carries 2-0 with one abstention. I need a motion to adjourn the meeting.
I'll make a motion to adjourn.
I need a second.
I second.
All in favor, say aye.
Aye.
The special meeting, public hearing held for Wednesday, August 23rd is now adjourned. Time is 8 p.m.